Good morning. Hello. Welcome to Maximizing the Online Economy and Making the Most of Your Copyrights, Part 2 for visual artists, designers, and writers. Thanks for joining us today. I'm Meredith Badler. I am the Program Director at CBCA, the Colorado Business Committee for the Arts, and joined today by Max Hass of the Hass Law Firm, who will be leading today's presentation. Hello. And also Rachel Henney behind the scenes, behind the screen, I think is what we can say now, who will be helping out as well, leading today's webinar. Before we dive into the content, I wanted to give a few housekeeping items and shout outs to some of our sponsors that is making it available for CBCA to do some of this programming. With the impacts of the coronavirus, we are acutely aware of the toll it is taking on our arts sector. So we're excited that we have wonderful attorneys like Max and other business professionals that are willing and frankly eager to share their knowledge and their expertise to help artists and creatives get through this challenging time. This programming is happening through CBCA in conjunction with two programs that we offer. The first is Colorado Attorneys for the Arts, or CAFTA, which is a pro bono legal referral service and legal education programming that we do for the arts and have been doing CAFTA for a long time, which gets support from Colorado Creative Industries, the City of Denver, Denver Arts and Venues, and the Colorado Bar Foundation. And then we also have programming called Advancing Creatives, which are other professional development and business skills education, and that is supported by the Kenneth King Foundation. So we wanted to thank them for giving us the ability to share this information with you. To help provide sort of the best experience, I feel like by now we're all getting pretty good at Zoom, but just in case, this is a Zoom webinar, so all of our attendees, you are muted. That's how you joined, so you can take comfort in that you are muted and your video's turned off. We'll be leading the conversation. If there is a time where we need to hear from someone or we want to open it up to have a conversation, myself or Max or Rachel as the moderators can unmute someone if needed. Otherwise, the best way to participate is actually through either the Q&A functionality or the chat feature. Those are probably towards the bottom of your screen, something that says Q&A where you can submit questions and then we can respond to those directly there. Or there's the broader chat and you can chat to just us, the panelists, or to everybody. As you will. We'll be keeping an eye on both the Q&A and the chat throughout. Max will be leading the presentation, and if he's, in the zone and sharing some wonderful information, as we know he will, Rachel and I will also be keeping an eye on the chat and can chime in and handle questions that need to be answered real time or towards the end of the presentation. So we know this webinar platform can be a little awkward, but there are ways to be interactive, to share your thoughts, to ask questions, to get clarification. There's a lot of really terrific information to share. And we are recording this webinar. We'll be recording all of our webinars going forward. And if you go to cbca.org, I think it's /advancing creatives, we've already started posting videos and resources of some of our past webinars, and we'll continue to keep that up to date. So if you need to hop off or want to share this with someone afterwards, we hope this can be a resource going forward. With that, it's my pleasure to introduce Max Hass. He's an entertainment and business attorney as well as a musician, so has some great experience being in the trenches in the creative industries, as well as working with lots of different musicians, filmmakers, artists, and creatives. The presentation will go over some basics of copyright law that are really essential to then using your creative work once it's protected and you understand your ownership, how to leverage that in sort of our online economy, which nowadays has become very important. So with that, we're going to do the screen share swap. I will stop sharing my screen and we'll turn it over to Max to share his presentation and lead us through this great content.
Thank you, Meredith. Looks like we got the screen share switched, so I'm going to go ahead and get that started. So hopefully everybody can see that now. Just get something set up here. Okay, well, thank you everybody for being here, being part of this. I know it's a challenging time, so you know, the fact that you're taking the time to do this means that you're trying to figure out how to sort of beef up your business and make the most of the situation. So we're here to help. And so as Meredith said, we're going to be focusing today on copyrights and how those sort of dovetail directly into your ability to leverage your skills and your creative work into commercial opportunities for you. So to get started, I just have to give you a little bit of a legal disclaimer just to kind of put everybody on notice that what we'll be talking about today is educational and shouldn't be deemed as legal advice. You know, there are some best practices that I'll mention throughout, but you have to keep in mind that legal advice is specific to your case, and I'm not going to be providing legal advice to anyone's particular case today. But if you do want to get in touch with me afterwards via email, I'm always available for a consultation, or we can refer you to the great network of volunteer attorneys that CAFTA has. So there are a lot of opportunities, but just note that this is educational. So a little bit about myself. As Meredith mentioned, I'm an entertainment attorney as well as a musician. I've also had some personal experiences in the visual art world and even worked on a few film productions here and there. But I started my entertainment law practice in New Orleans about 2.5 years ago, where I also attended law school. And I only just relocated to Denver about 6 months ago, but I'm very happy and enthusiastic to be part of the community here in Colorado. And over the past couple of years, my primary clients have been creators. So a lot of the stuff we're talking about today is stuff that I've seen firsthand in dealing with clients or even in my own personal experiences. And so, you know, I understand some of the specific situations that artists get themselves into. So if you do have questions about stuff that you're dealing with, I you know, rest assured that I have some understanding there. And then prior to becoming an attorney, I actually worked for a few years in the music industry, really getting to know how the business worked, which has given me a lot of insight into, you know, how to advise clients on these types of issues. So just briefly, to give you a little roadmap of where we're going to be going, we have sort of this very simple agenda here. As Meredith mentioned, it's going to start off talking about copyrights. And the reason this comes first is because this is absolutely crucial to monetizing your work. You really have to understand how ownership of copyrights works, especially when you're working collaboratively with other people, and understand the role that contracts play in ensuring that you are actually the one who owns the rights. And so we're going to start with that before kind of getting into the more sort of business side of things. But that way you have kind of a good foundation and framework to think about these issues. Let me just take a second here to make sure, am I missing anything in the chat? Kind of having a hard time pulling up that window. I'm just gonna get this over here. Oh, I see we have a fellow Tulane alum or someone connected to Tulane here, so welcome. Anyway, so the basic, just really important first thing I always like to mention at the beginning of these presentations, just because this is a pretty common misconception, and I see this getting confused pretty often, is that copyright is not synonymous with trademark or with patent. These are three different forms of intellectual property. So they do fall within kind of the same general area of law, but each of these disciplines, copyright, trademark, and patent, are established by separate federal statutes, totally separate bodies of law, and really they cover different things. A good way to think about it, just a really kind of simple guide for moving forward, is that copyright is only going to protect your creative expressions. It doesn't protect the kinds of things the trademark protects, and trademark doesn't protect the kinds of things the copyright protects. There's really separation here amongst these three areas. So copyright, think of that as anything creative, copyright's going to attach to that. Things like logos and brands, and not really the design elements of them so much as a company's ability to use those as a logo or a brand. Those are covered by trademark law. And then patent is really meant for inventions. It's not something that covers creative expression so much, but really focuses more on useful inventions and devices and things like that. So get a little bit more focused on copyright, because that's what we're really talking about today. To give you kind of a high level understanding of sort of generally where copyright fits in with the legal scheme, it's important to understand that it is a form of property. So it can be bought and sold just like any other form of property. Think of, you know, a bike or a car or a piece of furniture. Copyright pretty much functions the same way. You can rent it out to somebody if you want, which is what we call in the copyright world is licensing. Or you can actually sell your rights outright to somebody else so that someone else owns them and then you wouldn't own them anymore. It's complete, even though it is a form of property, it's not exactly coextensive with the artwork itself. So copyright is a separate piece of property. You have the original painting or sculpture or something like that over here, and there are basic property rights that attach to that. But then copyright is sort of this other piece of property that's linked to it. And we'll get a little bit more into that as we go on. And one of the most important aspects of this form of property is that it includes a very specific set of exclusive rights. We're going to go through those on the next slide. And the owner of that property, of that copyright, has those rights. And when I say exclusive, it means nobody else can exercise those rights during the time that that person is the copyright owner. So they can shut other people down from trying to make use of their copyright. But the trade-off is they only have those rights for a limited period of time. So if you think about, you know, where this sort of diverges from typical property concepts, is that as long as you own the couch in your living room, you have the rights to it. For as long as that piece of property exists, you will have rights in it. There is no point in time where all of a sudden the couch will become public domain. And so that's where copyright is different, is that at some point, the rights will just expire. And after that point, the copyright becomes part of the public domain and can't be owned or controlled by anybody else again at that point. That being said, the time you have is pretty significant. It's for individual authors or artists, it's the artist's lifetime, their entire life, plus an additional 70 years after they die. So it provides a lot of time for usually at least 2 or more generations of heirs to still be able to benefit from whatever uses the copyright is getting, whatever royalties it's bringing in, things like that. If there's a corporate author where, let's say, a film studio has, you know, a team of animators as their employees, in that situation, the company will actually be considered the author, and the duration rules are a little bit different. But for most of our purposes, we're going to be looking at the duration rules for individual authors, which is life plus 70. So it is actually impossible for your work to fall into the public domain during your lifetime. So you have these rights pretty much from the time the work is created until a very long time in the future. So those rights that are included in copyright, these are spelled out in the US copyright statute. So these are the core rights that come with every single copyright. So no matter what your work is, no matter how it comes into existence, if it's eligible for copyright, then it's going to get these 6 rights. You have the ability to copy the work, to get the work out into the world through distribution, to make derivative works, which are kind of a complicated concept that we won't really be talking too much about today. But as a way to sort of understand on a basic level what derivative works mean, I use the example of a film that was created from a novel, right? So the book is the original work, and then the film, because it's completely based upon the characters and storyline and other copyrightable elements of the book, the film isn't a totally independent copyrightable work. It's actually fully derivative of the original. So the owner of the book's copyright is the one who has the authority to to sign off on that film getting made. You also have the right to publicly display the work, which is pretty self-explanatory. Publicly perform the work is fairly self-explanatory as well. And for the most part, public performance doesn't really come into play that much for visual artists or writers, so we don't really have to worry too much about that. And there is also a 6th right, but that applies to sound recordings, so not really something we have to concern ourselves with today. So the copyright statute also specifically lists the categories of works that are eligible for copyright protection. So what that means is that if you're creating something that maybe doesn't fit into one of these categories, there is a possibility, not a guarantee, but a possibility that it might not be eligible for copyright protection. But that being said, these categories are pretty broad. So these are just some examples that I've provided of what is included in the category of literary works, for example. But there are many, many more things that could count as literary works. So I've highlighted for you the 3 categories that are probably most relevant for today. One of the reasons I've brought this up is because these same categories are also what the Copyright Office uses when you go to register a copyright. And so you have to select one of these types of works as the very first step in the registration process to let the Copyright Office know what kind of work it is that you're registering. And in turn, that's going to affect some sort of small aspects of your registration in terms of what you need to submit to the Copyright Office as a deposit copy and things like that. And we will talk about that more later. Because each of these types of works has slightly different rules. So for example, in music, you can just go ahead and upload an MP3. For a lot of literary works, you can upload just a PDF or a doc file. But for things like computer programs, there's specific rules on what you need to submit. For large-scale sculptural works, there's some specific rules because the Copyright Office doesn't want you shipping a massive sculpture into the Library of Congress office. But we will talk more about that in a little bit. Okay, so the other thing to be aware of is that even if your work falls into one of those 8 categories that was just listed on the previous slide, it still has to meet the basic threshold requirements for copyright eligibility. So even if you have something that would count as a literary work, you still have to look and see, does it meet these two requirements? You have to have both of these requirements there. So first, it has to be an original work of authorship, which means not that it has to be something totally novel. It doesn't need to, be this groundbreaking work of creativity by any means. But it does have to have at least a minimum degree of creativity. So it just means, things that involve some kind of creative spark on part of the author. It also has to be a human author, which may seem sort of obvious, but there have been some attempts in recent years to try to get a copyright over things that were created by AI or by sort of a special algorithm. There was even a case a couple of years back where there was a chimpanzee that went up into space, and someone tried to claim that the chimpanzee owned the copyright of a selfie that he took or something like that. But no, it has to be a human author. Otherwise, there can be no copyright that attaches to it. Then the other really important requirement is that the work has to be fixed in a tangible medium of expression. And I use this language because this is what's in the statute. So it's important to make sure that you're hitting all of these requirements. So fixed just means that it is exists for more than a short period of time. It means that it's written down somewhere or somehow recorded in a way where another person could come along and see or hear what you've done, and if they wanted, would be capable of copying it. That's really the core of copyright, is that the right you have as the artist protects you against other people trying to copy your work. So if it's not possible for them to copy it because it's still an idea in your head, then it won't count as fixed. And so you won't be able to get a copyright over it. When we say tangible medium of expression, there was a time where that meant it had to be in some sort of hard copy, but the Copyright Office has kept up with modern technology, and things like digital files, digital photographs, digital illustrations all count as tangible mediums of expression, as long as they can be saved and accessed somehow. So you have to meet these two requirements, and your work also has to fall into one of those 8 categories. And if you're all good on all of those things, then you can get a copyright. So then the next question is, all right, well, if I can get a copyright, well, then when do my rights start? And the answer there is really simple, actually. It's the very same moment that you fix the work in a tangible form. So as soon as you have created a sketch, or if you're a musician and you've recorded a demo, you've written down, the first draft of an article or a poem or of an art or a book that you're writing, any of that will count as fixed in a tangible form. And that is also the same moment where your rights begin. So from that very moment the work is fixed in a tangible form, you have all 6 of those rights that were listed on the previous slide. You don't have to go and register the copyright in order to have those rights. That's another common misconception, is that you sit sort of unprotected for some undefined period of time until you go to the Copyright Office, but that's not true. You have the copyright from the very moment the work is created. So just to kind of help you understand the limits of copyright, there are certain things that can't be copyrighted. And this isn't really, an exhaustive list. This is just really to kind of show you that there is kind of an outer limit to this. There's certain things, I'll let you guys read this slide, but there's certain things that can't be copyrighted because they're not fixed. There's other things that can't be copyrighted because there's not really enough originality. And then there's policy reasons why certain things can't be copyrighted. So, very familiar symbols and things that are used every day by pretty much everybody can't really be copyrighted, because remember, copyright's a set of exclusive rights. It basically gives the owner of a copyright a monopoly over that particular creative expression. So if someone were able to get a copyright over a basic square, then that means they'd be able to stop other artists from using squares in their artwork. And copyright law isn't really supposed to do that. So that's where we kind of draw the line and say there has to be something more specific and unique to that artist. It can't just be a generic shape that anybody could use or come up with. Kind of more specific one is that the overall layout of a web page is not copyrightable. The text, photos, and other creative elements of a website are, but you can't stop somebody from designing a website that has a navigation bar across the top. That's sort of the layout and format of a web page, and everybody does it. And it's kind of a similar theory to the familiar symbols idea, is that if we were to give someone a copyright over an overall look and feel of a web page, then other people wouldn't really be able to create web pages very easily in the future. So that's the basic reason for that. There are also certain things that can't be copyrighted because they're covered by other areas of law. So remember, I explained earlier that there are differences between copyright, trademark, and patent law. If something falls squarely within patent law, like a functional design or procedures and other things that you see listed here, then there's no reason for copyright law to apply. And so Copyright Office, federal judges who rule on copyright and patent cases, all of them are going to agree this is covered by patent law, therefore not eligible for copyright. Similar with trademark. There's certain things that are covered pretty much exclusively by trademark law, and as a result can't be covered by copyright We are going to talk a little bit about trademark a little bit later, but I'll just mention this now. A lot of artists have come to me over the years and asked, oh, can I get a copyright over this painting? And I also want to get a copyright in the title. Well, you can't get a copyright in titles. It's just a statutory rule of the copyright law that titles are not eligible for copyright protection. And for the most part, a lot of titles are not really eligible for trademark protection either. You can get a trademark in titles of a series. You can get a trademark in the name of a business, but of a work of art, the name itself is not really something that you can prevent other people from using. So that's why you see a lot of songs out there that have the same name. And a lot of works of art have the same name. And there's kind of practical reasons for that I don't think I need to really explain. So once you kind of understand all of that, and you know sort of how copyright works and what the limits are and what rights you have to sort of the next major thing you have to figure out is who actually owns those rights. And so there's some really important terminology in the copyright statute. And these are terms that may seem like simple, plain English, but they actually have very specific meaning in the context of copyright law. So the two terms here we're talking about are authors and owners. So the author is the creator, the person who actually came up with the idea, sat down, executed it. It's their creative expression. The owner, on the other hand, is the person who actually owns the copyright. So they're the one who has the authority to make various decisions about the work, whether they want to license it out, whether they want to make copies of it, whether they want to distribute it around the world. Often the author and the owner are the same person, but they don't have to be. So it can get a little bit tricky sometimes, especially when you get to situations with multiple authors. But the basic idea here is that if an artist creates something completely on their own, completely independently, there's no collaborators and nobody hired them to create the artwork, then that person will be considered the author. And then one of the basic rules of copyright is that anyone who is an author automatically becomes an owner of the underlying copyright. So, like I said, independent artist example, if you're the author, there's no one else involved in the project, you will then also be the owner of the copyright. On the other hand, it is possible for multiple people to be considered authors of the same work. And I'm sure as artists, you've experienced this in your own careers. I know that I have lots of clients who have this experience. If you are collaborating with others and you're all kind of on equal footing and you're all making creative additions to the project such that, you know, their contributions do qualify as copyrightable, then the law will see you as co-authors in a joint work. And the real key there is that all of those collaborators have to intend to merge their talents into one unified work of art. If you have one person who worked on something back in 2015 and then another artist finds it online, is really inspired by it in 2020 and decides to add their own sort of modifications and flair to it, there was never any intent for them to create one single work of art together, right? You only had that one artist back in 2015, and then another artist later on decided to sort of make their own spin on it. Those won't be considered co-authors. That's actually more of a derivative work kind of situation. And so because when you don't have that intent, people won't be considered co-authors. However, when you do have that intent, let's say you and another artist are getting together and you say, we want to create a collaborative work together, you'll be joint authors, you'll be co-authors in that joint work. And the same basic rule applies here, is that anyone who's an author is automatically an owner. So what that means is when you have multiple authors, you will become co-owners in that copyright. The co-ownership of copyright works in a very similar way that co-ownership of any other form of property works in our country. And one of the key concepts there is, somebody asked how much input or collaboration is needed to divide the authorship. Well, there isn't really a clear line as to what counts as enough, but the real key to look at is you have to assess each author's contribution independently. You have to look at it and say, okay, first, each author's contribution has to be independently copyrightable. So it has to be an original work of authorship and it has to be fixed. And then the next thing to look at is, okay, you've got these two artists, both of them had copyrightable contributions. Now the question is, did they intend to create a joint work together with these copyrightable contributions? Or did they intend to create sort of two pieces or two separate works that maybe were meant to be a series or something like that, but they aren't intended to be the same work? So, while there isn't a clear line, what I can say is that to be enough to sort of count as a co-authorship situation, it has to be more than a trivial contribution. So, if you're working on a painting and a friend of yours came into your studio and said, why don't you try, this shade of green? And that was the only suggestion they made to the entire project. That's not really going to be enough to count as authorship. If they took it a step further and they maybe put one or two brush strokes on the painting and you did the rest, also probably not going to be enough. So it's kind of a spectrum, and the law in copyright, judges are generally reluctant to create really bright line rules, especially in the world of art, because judges don't want to sort of supersede their role as a arbiter of the law and get into the world of making decisions about what is art and what's not. So judges are a little reluctant to go too far with that kind of stuff, but it's really comes down to the facts of a particular situation. So, frankly, the artists involved will probably know better than anybody else whether the contributions of a collaborator were really enough to count as authorship. And there can be disputes about that, but the idea is it has to be something more than just a trivial kind of suggestion or, very, very small contribution. The example I used yesterday in music is people are writing a song together and someone contributes, one word or one line to the lyrics. It's probably not going to be considered authorship. But on the other hand, if the line or the word that they contributed is what makes the song a hit, then they might argue that it was, a really significant contribution. So there are different ways that can play out. But getting back to co-ownership, what's important to realize here is that if you are co-owners of a copyright with somebody, each of those co-owners has the right to use the entire work as if they're the sole owner. And there's some limits to that. But it's really important that you understand this, is that the default rules of copyright law say that co-owners, even though they own their shares sort of in proportion to either their contribution or to how many people were involved, they still get to treat the work as if they basically own the whole thing. Now, you can modify ownership and co-ownership issues by contract. So these are default rules that are in the statute because we need to have something there that kind of establishes who's an author, who's an owner, what do they get to do with it. In the event that there are no contracts there, we have to have something to kind of regulate that. But the copyright statute also says that the parties are free to contract however they want to modify ownership and co-ownership issues. So to get a little bit more detailed, just so that you're aware of what co-owners really can do here, if you have, let's say, two people who collaborated on something, and we're in the default scenario, so there's no contract in this example. You have two people who collaborated on something. First off, the law is going to say that they are co-owners in equal shares, which means they each own 50% of the work. If it were 3 people, it would get divided up equally amongst those 3 people, and 4 people, and so on. And then the next step there is, okay, so you're a co-owner in the copyright. What you can do is issue non-exclusive licenses and exercise all of those exclusive rights that were listed on our slide earlier. All 6 of those rights, any co-owner can exercise those. But the catch is that they are obligated to take whatever money they made from the exercise of those rights and pay their fellow co-owner in proportion to their ownership share. So let's say you have these 2 artists who are collaborators on a project. One of them is doing all the work of getting it out to online stores, getting it licensed, getting it used in films, all sorts of great commercial opportunities for the artwork, and the other collaborator isn't really doing anything at all. But they don't have a contract between the 2 of them. In that scenario, all of that money that the first artist made from all of those licensing and other commercial activities, you still have to take that money and split it in half and pay the other person their half. And unless you have a contract, that is how that works every time with copyright co-ownership. So this is why this helps to sort of really drive the point home of why contracts are so important, is that you can shift ownership entirely. So you could get a contract between those 2 collaborators where artist number 1 ends up owning 100% of the copyright. Or you can maybe say, you know what, instead of 50-50, let's do 70-30, because I'm going to be doing so much more work, and I think that I deserve a bigger piece of it. You can do any numbers you want. The other thing you could do is you could keep the ownership at the default 50-50, and you can assign what's known as administrative rights to one of the 2 artists, so that only one person has the legal authority to actually go out in the world and exercise those rights. Now, administrative rights are kind of industry created. It means generally the ability to exercise those rights. It's not something that's actually spelled out in the statute, but it is something that is commonly used in contracts between collaborators to establish who has the authority to go out and issue payments. There's a lot more that you can do with contracts, but I bring this up now because the co-ownership issue is something that I see over and over and over again with artists who work collaboratively on projects. Another thing to keep in mind is that these rules of co-authorship and co-ownership will apply regardless of what you think your dynamic is with your collaborators. So in the sort of easiest scenario, you and the other artist might be on equal footing and you see yourselves as true collaborators, and that will be, a co-authorship kind of situation. But even in the scenario where you hire assistants, or you have a team of employees who help execute large scale works, or they're doing research for you, or they're otherwise, helping contribute to the copyrighted work, even in that scenario, co-authorship will likely still apply. And the reason I mention that is because usually the parties involved subjectively don't think that that's the case, right? But the copyright law doesn't really investigate that deeply. Copyright law just looks at whether the person made a non-trivial creative contribution to the work and whether there was an intent to merge talents into one unified work. And if those 2 things are there, then there will be co-authorship. And so that's another area where contracts are really important, because if you're hiring assistants or you're having people work for you, the law is going to give them a piece of ownership in your copyright, even if you don't intend that to happen. And so the contract becomes really, really important there to make sure that the law is on your side in that scenario. Similar things can happen when you as an artist get commissioned by another person to create something. I've seen this with many of my clients. They get commissioned by somebody who doesn't really know anything about copyright law, and then they think that because they paid the artist that they're entitled to ownership of the copyright. But it's a little bit more complicated than that. And a contract, again, will help clarify who owns the copyright in those situations. So it looks like we have another question. Okay, this doesn't really look like a question. So if whoever submitted the most recent question maybe wants to email me, that looks like something we could discuss. We could discuss offline, but it's looking like your question has a lot of detail there that maybe suggests you're looking for advice. So we're going to have to hold off on that. But do feel free to email me directly and we can discuss just where we have kind of a more confidential channel to communicate. So after all of that, what I just said about co-ownership, I do just want to sort of really emphasize the point that contracts become hugely, hugely important at two different phases of the creation of a copyrighted work. You have sort of phase one, which is either the planning period before you start a work or maybe during the process of creation. That's where you're hiring other people, you've got collaborators involved, the work is being made. The types of contracts that you need to use in that scenario, in that phase of the project, have everything to do with these co-ownership issues that I just mentioned on the previous slide. The goal there is to establish a clear chain of title as to who owns the copyright. Now, if you've got a situation where you're just working on something by yourself, then you don't really need this phase because you're not going to have any co-authorship issues. But if you've been commissioned by somebody else, or if you've hired a team of assistants or other collaborators, the contract that you use can include copyright ownership clauses that help make it clear which person or people own either the entire copyright or co-own it. You can also establish who has the administrative rights. And these are really important to get these contracts together, because then phase two, when the time comes to go out and talk to distributors and licensing agents and galleries and other people who want to make sure that they're protected, they're going to want to see that the artist has clear chain of title to the work, because they don't want some unknown copyright co-owner to pop up out of the woodwork 5-10 years down the road demanding a share of the royalties or suing for infringement or otherwise causing some kind of headache. So it's important to get the chain of title established early on. I always suggest to clients to do it as early as possible, because that's when everyone's usually on good terms, everyone's excited about the project, everyone's willing to talk to each other and discuss details. If you wait till after the project's over, it's notoriously difficult to get people to sign contracts. And there is always a risk that you sort of send the wrong message to them if maybe early on they thought you were collaborators, and then all of a sudden a contract appears where you take all the copyright from them. And so it can get a little hairy if it doesn't happen afterward, if it doesn't happen beforehand. That said, there's no actual timeline there. It's never too late to get those contracts in place as a legal matter. So it's always important to really look at these issues of authorship and ownership and determine whether or not a contract might be necessary to really clear up that chain of title. And then when you do have that all straightened out and the time comes to go talk to third parties, maybe bigger companies, other parties that have financial resources to license your work from you or to buy your work from you, then you're looking at a different types of contracts to use. You have either licenses, which I mentioned earlier is sort of the copyright equivalent of renting something out, or you might have an assignment, which is an outright sale of the copyright. So, assignments can sometimes exist as standalone contracts, but more frequently, it's actually just a clause within a bigger contract. So you might have a contract with a gallery or with a publisher or with a distributor where they're requesting that they own a piece of the copyright. It might be some long form publishing deal where only one paragraph in there is going to effectuate an assignment of copyright. But that is relatively common practice in certain fields, that the companies taking a bigger financial risk to market your work, to distribute it, to really spend money trying to get it sold to the general public, they usually like to sort of secure their investment by owning some of the copyright. And so that's why assignments are used. Licenses are a lot more common. They also more commonly exist as standalone contracts, because in a lot of cases you can issue licenses over and over again for the same work, as long as they're non-exclusive licenses. And so this is a very, very common way to generate revenue from your copyrights directly, is through licensing it out. But as the previous couple of slides have showed you, if you don't have a clear handle on what the ownership of that copyright is, or you don't have a clear understanding of what kinds of things you can do with your copyright, then you're going to have a hard time with licenses, because you really need to know, okay, what am I licensing to this person? Am I giving them the entire copyright, or am I only going to give them one of the 6 rights? So for example, you might be a painter or a photographer and want to have prints made of your work. If you contact a print shop and get prints made, and that's all they're doing for you, you technically need to give them a license to make copies of the work, because they need to be legally authorized to reproduce your work. But that license doesn't need to grant them any other rights. You only have to give them the copying right. You don't have to license them the entire copyright in order to do that. On the other hand, if a film production comes to you and they want to feature your painting in a scene in one of their shots, or in a room that they're filming in, you might have to license more of the copyright to them, because they're going to include your image in the film, and then that film itself is going to be reproduced, distributed, publicly displayed, publicly performed, and so on. And so in order for them to have the rights to do that with the scene that includes your artwork, they need to have all of the 6 rights, or at least a license to all of those 6 rights, in your work in order to do that. So I hope that is clear, and I just kind of want to pause here and see if anybody has any questions involving contracts or any of the sort of copyright basics we've talked about so far, because we're about to sort of transition into the second half, more or less, of the presentation. Looking like maybe the answer is no. Okay. Well, so the reason all of this stuff came first is because when you do go to actually register a copyright, these next couple slides just gonna sort of walk you through how to get to the Copyright Office and get the registration process started. But in order to complete this step, you have to make sure that you understand the authorship and ownership of the work that you're registering, because the Copyright Office is going to ask you for that information. And you don't want to input, I mean, if you're mistaken about something and it's just an honest error, it's not necessarily a big deal. But if you input the authorship or ownership information incorrectly, and it's legally significant, there's 2 possible results. One, it's possible the Copyright Office will actually refuse your registration. And there's kind of some nuance to that I won't really get into, but if anyone wants to ask me about that, I have a client who just dealt with that a couple weeks ago. Or the other possibility is that the other author, the other owner, might notice that you left them off the copyright registration, and then they could actually come after you with a legal claim that you're sort of improperly taking their copyright from them. So really important to just make sure you have all of the information you need all together in one place before you go to register the copyright, because you want to make sure that you've got the information correct when you get started. You will also need the work itself, or some copy of the work itself. So you can't really go to register the copyright if the work's not complete yet. And that kind of goes back to the basic idea we talked about earlier, which is that in order to be eligible, it has to be fixed in a tangible medium of expression. And so if the work isn't done yet, but you're trying to get a copyright over the work as it will look when it's finished, then you need to register the work as a finished work. So just very quickly here, this is the homepage. When you go to copyright.gov, this is what you'll see. Don't go to copyright.com. That's a private company that tries to basically get you to pay them as a service fee to go and register your copyright for you, but it's not the Copyright Office. And the only place you can register a copyright is at copyright.gov. So you have to make sure you're on the right website. So right here in the big red circle, that's where you'll click. You can't click on the photo, you have to click on the word register. But once you do that, it'll take you to this next screen. Down here at the bottom, they'll ask you to log in to the Copyright Office registration system. And then once you click that button, you'll come to this next screen here. And if you have an account already, you just enter it, log in, and then you'll see all of your options in terms of what types of registration forms you can use. If you already have existing copyright registrations, either pending or have already been approved, all of that will be in there as well. So you can always go back and look at your old files, basically. And if you don't have an account, it's free to create one. It is required, so you do have to go and register in order to get past this step and start working on a copyright registration. So I mentioned earlier that you have these rights, you have those 6 exclusive rights as soon as the work is created, right? So then the question is, all right, well, why should I register a copyright? There's a lot of very, very important reasons to register a copyright. One of the most important, even though I have it listed as the second bullet point here, is that a registration certificate from the Copyright Office is required if you want to file a copyright infringement lawsuit. So if you find that someone else has taken your work and is using it improperly and you want to go after them for copyright infringement, you can go ahead and send a demand letter, a cease and desist letter, and all of that. But when the time comes that you actually have to file in federal court, the judge is going to require, because the Supreme Court requires this, that a copyright registration certificate be accompanied with your complaint when you file it. So you can't get anywhere further than cease and desist letter. You can't go into court if you haven't registered your copyright. So that's a major, major reason why to do that. And then even if you never end up in court, the other really important thing about copyright registration is that there is a legal presumption that is created that you own the copyright and that the copyright is valid if you register within the first 5 years after publishing your work. So if you register the copyright, then the whole world, courts, other artists, their attorneys, Copyright Office, everybody will have to assume that that means that you own that copyright and that your copyright in that work is valid. And so because of that, it's important not only in sort of the litigation setting, but also when it comes to commercial transactions. If you want to license your work out to distributors, to publishers, to other outlets, they usually want proof that you own the copyright. Again, they don't want any surprises later on. And so that copyright registration will give them a lot of assurance that you actually own it and that they can feel comfortable moving forward with you and using your work without fear of getting sued by somebody else. Another really important thing, if you are in the litigation setting, is that if you're very prompt with your registration and you get the work registered within the first 3 months after you publish the work, you can actually be eligible for attorney's fees in the lawsuit, which means that if you win, the other side has to reimburse you for your legal fees, which is really important because you wouldn't have to file a lawsuit in the first place if it weren't for this person infringing your work, right? But you can also elect to use statutory damages, which is a special provision in the copyright law. It basically says there's a sliding scale of damages that judges have discretion to award if the plaintiff chooses to go that route. And what that does is it means that the plaintiff doesn't have to actually prove the specific amount of money that was lost or that the defendant gained in that situation. And it's really helpful because it can be really difficult to prove that sometimes. And in many cases, maybe there aren't sales per se, and there aren't necessarily monetary numbers you can use to illustrate your damages to a judge or to a jury. And so if you have statutory damages available because you registered your copyright in time, it can give you basically a clear path to getting some kind of financial compensation in an infringement setting. But again, you have to register within very specific periods of time in order to have access to those. So it just kind of helps to really emphasize how important registration is, and really how important it is to register sooner rather than later. I also like to tell people, because of all these benefits and because of the fact that copyright registrations are not very expensive, really think of it like a really cheap insurance policy. The office actually just a week and a half ago recently raised their registration fees slightly. It used to be $10 cheaper, but even still, now we're looking at $45 for a single work, $65 for a registration that includes multiple works. So either way you slice it, really doesn't cost that much to get these benefits of copyright registration. It's also important to note, because this is another thing that people ask me about, is that mailing yourself a copy of the work and leaving the envelope unsealed, that is not the same as registering a copyright. So you're not going to get these benefits. And that's why it's really important to actually go to the Copyright Office, register with them, and that will open the door to these presumptions of ownership, statutory damages, and your ability to file a lawsuit. So can't get those things if all you do is mail the work to yourself. So registration is important. As I mentioned earlier, there's a couple things you need to have in hand ready to go when you go to register. I've got a lot of text up on this slide, so I'll give you a second to read through that. But you really need to have all of this stuff ready before you at least submit the registration form. One nice thing is the Copyright Office does allow you to basically save a draft. So you can always go back to it and keep adding things. But by the time you're ready to hit submit, you need to have all of these things together. You will pay the registration fee at the time that you submit the form to the Copyright Office. And the Copyright Office will determine, based on what you've put in the form, what fee you owe them. Some situations you may have, if you have like a lot of works you want to register, you might have to split them up into multiple registrations. That's a little bit nuanced that people, if you have questions about, you can definitely ask me. But generally, you're going to pay either that $45 or the $65 per registration. You also need a copy of the work to deposit with the Copyright Office, because they need that registration form to be permanently attached to whatever work it is that you're claiming copyright over. That way, if there are any disputes or if there's ever any question and the Copyright Office needs to get involved in any way, let's say someone subpoenas the Copyright Office to provide a copy of the registration form, they need to be able to see what work that was attached to, because the registration form itself is just text. You'll have the name of the work and you'll have the names of the authors and the owners, but you won't have a description of the work. You won't have any images of the work. You have this separate deposit copy that resides at the Library of Congress with your copyright registration number attached to it. And that's what's used to make sure that the registration form and the authors and owners that are listed there are properly connected to that particular work of art. So like I said earlier, you'll have to have whatever version of the work you want to claim rights in. You have to have that ready in order to finalize your registration. They ask that you upload your deposit copy. Doesn't have to be immediately at the same time you submit the registration fee, but I believe it needs to be within no more than like a few days at most. So definitely best practice to just have everything ready to go. And then that way you can sit down, takes 10 to 15 minutes, and you can get a copyright registered relatively easily. Okay, so we're gonna sort of shift gears now that you have hopefully a better understanding of copyright law and how this works for you, as you can do now to help make the most of those copyrights. Because ultimately what you have to understand, if this wasn't clear already, monetary in the works of art you create is ultimately derived from that exclusive set of rights that you have. The reason it's valuable is because you have a monopoly over it. And so if you are in a situation where you're not really enforcing your rights, or you're not really carefully controlling them through contracts and other things like that, then you're basically giving away value that you have in your hands the ability to really control. And so that's why I always recommend to clients to really try to, shift away from that mindset that you're, an individual freelancer and, work comes whenever it comes, and really try to shift over to a more proactive approach of thinking about your work and your projects as a small business. Really get serious about setting it up as a small business, because once you have that sort of legal framework, and then you also have things like sort of standard policies and procedures, and you have a standard copyright policy in terms of what you let people license from you, and so on, you'll actually be able to create more demand and more value for your copyrighted works as you move forward. So that's what the next slide will really focus on. And then another important point is that there are some organizations out there known as collective management organizations that actually collect royalties on behalf of artists. And it's a little bit complicated, and I'll talk more about it in 2 slides, but they're out there collecting royalties for artists whose work is getting reproduced in various different ways. And it could be another revenue stream for you. If your work is already published and already out there in the world, these collective management organizations may be able to add another source of income for you. So the first thing I'm going to dig into here is shifting your approach from an individual to a small business. Now, the first thing I want to mention is that with everything that's happening with this economic crisis, as I hope that many of you already kind of realize, is that retail, commissions, and licensing are all still very viable market opportunities for you as a visual artist. Retail transitions from in-person to online very easily. There's already tons and tons of online retail taking place. And so it's really just up to you to get your work positioned in such a way that you can start really treating it like a retail operation. Similarly, in-person interactions aren't really required for you to get commissions, right? As long as people can get a hold of you somehow, and you have a studio space to work in, you can definitely still do commission work for people. Similarly with licensing, as long as people are able to get a hold of you and your work is ready to go, you've got digital files, you've got a licensing policy already established, then you can be licensing your work out to various things. So the first step that I would suggest to artists, if you don't have this already, is to set up an LLC. There's a lot of different reasons why LLCs are important, but I'll focus on kind of the most important aspects of it, which are that it creates a separate legal entity, which allows you to really create some separation between your personal assets and your business assets. So if you're making money from your art, but you also have a side job, you own a car, maybe you own a house, your LLC is where all the business assets live, and your personal assets are not included in that. But without an LLC, everything legally speaking is all the same. The law isn't going to create that separation for you just because you think of your business as something separate from your personal activities. But the LLC is what allows you to legally sort of put that wall up between them. And that's really important if you get into any kind of liability situations, because if, for example, someone were to sue you because of maybe a breach of contract issue and they were to get a judgment against your business, the only thing they have access to collect on that judgment are the assets of the LLC. They can't go after your house and your car and your money from your other job and things like that. So having that shield is really important on sort of the liability side of things. But in terms of just managing a business, it also allows you to really create kind of a totally separate framework for generating revenue, and for structuring your business in kind of a more formal, sustainable way. One really important thing to note is that setting up an LLC is usually relatively simple and fairly cheap. Here in Colorado, it's only a $30 registration fee with the Secretary of State. I'm also licensed in New York and Louisiana, and in those states, it's only about $100 to set up an LLC. I don't know for certain what the fees are around the country, but I assume that most states are kind of in that range of somewhere between $30 to $100. One example I do know for sure is California is actually very expensive to set up an LLC, and it costs $800 there. But I assume that most people here are from Colorado, and so you have one of the cheapest options for setting up an LLC. Let's see, the one other thing to kind of to touch on there is that when you do set up an LLC, you're sort of making that first step toward creating a business that might have kind of its own brand identity. Now, maybe your business is your name art studio or something like that, which is totally fine, but that's still a different title than just your name, right? And so it gives you a sort of a new opportunity there to try to maybe build some branding, build something of a logo or some other sort of recognizable brand identity that will help sort of strengthen in the eyes of potential customers out there. It really helps strengthen their recognition that this logo, this company, this name is associated with some high quality products that I really care about. And so when I see their logo, I know that it's going to be high quality art. And so, I mentioned earlier that I would touch on trademark law. This is where trademark can actually come and really help you and really to be to your advantage, because once you start building that visibility and that brand recognition, trademark law actually allows you to get a similar type of exclusive claim over that brand name or over the logo that you use, somewhat similar to how copyright works for art. When I say exclusive, it kind of means the same thing. If you claim a trademark in your company's name or in the logo that you use, you are the only person who has the right to use that name in connection with that field of business. So if someone else tries to use the same name and is also running a competing art studio and you have a trademark over your name, you can actually stop them from using that name, which helps further strengthen your brand and just further reinforces out to the sort of general public that you have this strong brand identity. Some other, practical tips that aren't maybe strictly legal advice, but I do work with clients in sort of business counseling as well. So these are some things that cross my mind is, really making sure that your online presence is as good as it can possibly be. So if you don't have a website or you have kind of an old outdated website, maybe you have some social media pages and they are in need of some sprucing up, now is a great time to do that. For one, you've got a lot of time. And for two, there's really minimal other avenues for people to find you right now, right? And so being visible online is going to be your key to business coming in and your ability to continue making money from your art, and hopefully will allow you to actually increase whatever it is you've had going on. So, one of the most important things that I'll stress there is really go through and make sure your contact information is available everywhere. Double check to make sure there aren't any typos or anything like that. Get whatever your current email address is, your current phone number, if you're okay with putting your phone number up. Maybe think about creating a Google Voice number if you don't want to make your cell number available. Get that up on your website, get that up on all of your social media pages. Make sure that anywhere people are looking for you, they can find you and they can get a hold of you, because whether that's someone who's looking to license your work, someone who wants to commission something from you, or someone who wants to just buy some retail products from you. Maybe you have, prints or other, gift type items that people might want to buy. If they can't get a hold of you, there's not really any other option right now. It's not like they can go find you at an art market or go to the gallery that your work is hanging in, because none of that is an option right now, right? So, and this stuff will carry over even after things have returned to normal, because a web presence is really becoming kind of the new norm for most businesses. Is if you want people to find you and use your services or pay for the goods that you're providing, and they can't find you, or even if they find you, they don't know how to get a hold of you, they're just going to move on to whoever they can find. Unless they really, really specifically want your art and they'll, stop at nothing to find you, chances are most people, the average person, is going to not really spend a lot of effort doing that. And they're going to move on to someone that they can get a hold of. I do have kind of more detailed stuff written down, but I think that pretty much covers it. One other thing I would suggest, and this is sort of ties back into copyright, is that people want to see what your work looks like. So definitely recommended that you include samples of your work and put that up there so that people can get a sense of what it is they'll be getting from you. But if you're concerned about, people maybe downloading images from your website or taking screenshots of social media and reposting your image without permission, you might want to consider using watermarks. And the reason I suggest that is because if you don't use a watermark, someone reposts one of your images and you're not happy about it, you're going to have to spend time and energy, and it's going to create a lot of stress and headache trying to chase them down, write them angry messages, try to get them to stop, right? That's just a lot of wasted time that you really don't want to spend your time doing. But if you can do something more proactive, such as watermarks, or maybe, there's some more sophisticated tech solutions as well that I don't personally know how they work, but I know that they exist. Things like that will prevent people from copying in the first place will allow you to just keep going about your business without really having much to worry about. And of course, you can always provide a link that says, contact me if you'd like, an unwatermarked sample or something like that. So a lot of options there. Moving on to just kind of get a little bit more specifically focused on some licensing and commission things. This is an area, as I mentioned before, where contracts are hugely important. You've got the copyright ownership issues that you need to make sure are addressed, because you don't want things to be sort of vague or confusing as to who owns the rights and what each party can do with it. And that really applies in both cases, right? So whether or not it's a license situation or a commission situation, copyright ownership is going to come up as an issue. And so that's where contracts really will help make sure that there are no disputes that come down the road with that. When it comes to licensing, there's, I don't know if it's literally endless, but there are just so many ways that visual art can get licensed for various things. I mean, you've got things like housewares and other retail goods where maybe the art can be reproduced in sort of a screen printed kind of way. You can obviously get prints made so that people want to, hang your art up in their home or in their business. But they can also appear in things like films and TV shows and commercials. They can be used as covers for books. I mean, all sorts of things that you can do with licensing. And so one of the things that I would really stress there is if you have works that you think, licensing is an avenue that works for you and that would be, really conducive to your business, or really that your art is conducive to licensing, really, really strongly recommend that you take the time to develop sort of a standard licensing policy, maybe even go so far as to work with an attorney and create a standard licensing document so that when you get requests, you have that document ready to go. You already know what your standard terms are going to be. You already know what you're charging for different types of licenses. You already know what your delivery terms are going to be. And really what that does, I mean, aside from saving you time and allowing you to not have to reinvent the wheel every time you get a request, it also really sends a message. I have some clients or some former clients who have, they're independent artists. They have their own LLC, but it's, one or two person little art studio, but then they get fairly big companies coming to them requesting licenses. And the first couple of times they got those requests, they didn't really have, the art studio didn't really have a standard policy. And so as they got that request, they didn't really know exactly what they wanted to say in response. And it turned into this sort of long drawn out conversation where there was some discussion early on of the copyright issues, but then later on, as it got more detailed, the company that was interested in licensing actually sort of got turned off by the whole conversation because they thought that, well, basically their understanding of the copyright issues was not what it actually was. And so it sort of soured the whole conversation. And related to that, I mean, the other thing is that bigger companies that have a lot of resources tend to view independent artists as, not really knowing what they're doing or what they're talking about when it comes to business issues. And they tend to think that they can take advantage of artists. And so if you already have a sort of you're running your business like this smooth, well-operating machine, and you have a standard licensing policy, then someone sends in a request and you come back with that, that's going to let them know that you take this seriously and that you run your studio like a business, and that they either have to agree to the terms you've set, or else, they can go somewhere else for the licensing. And I don't mean to say that in a way that's like, you want to be turning down business. You certainly don't. But the point is parties to take you seriously and to respect your copyright and to respect your payment terms. And so something like a standard licensing agreement that's used any time you license your work will help really establish that in the eyes of third parties. And ultimately the long-term result is I think you'll see more business coming out of that, because ultimately, more sophisticated companies are generally impressed and want to work with other sophisticated companies. And so if that's how they start to view your art studio or your business, I think that the long-term result will be actually more revenues for you. In addition, you spend a lot of time negotiating terms if you have to reinvent the wheel every time. And so this can save you a lot of time and ideally allow you to engage in more transactions per month or per quarter. And obviously that means more revenue. The less time you can spend per transaction, the more transactions you can fit into a day or into a week, right? So a standard policy will really help with that. The important things to focus on when you're crafting that policy is you really want to think about what your pricing is going to be. And on that note, you might want to think through different licensing options, right? So you might want to have a certain price for non-exclusive licenses. You might want to have a different price for exclusive licenses. And I would suggest that you go, You go up on your price for that, because if you issue an exclusive license, it means that you won't be able to license that same work to anybody else during the term of that exclusive license. So that's, if someone's going to ask for an exclusive license, you want to make sure that whatever your lost business opportunities as a result of tying up the work exclusively, you're going to get compensated properly for that. You also really want to think about, how and when do you get paid? Don't let the other party dictate when they pay you or what the payment method is. They're coming to you because they want your artwork. They want the value that you provide. And so if you sort of proactively set out a policy of what methods of payment you take and when you need to be paid and when things will be delivered, along things like that, then again, it sort of helps increase your bargaining power when you're in those conversations. You also want to think about how you're going to handle copyright issues. So with licenses, obviously retaining ownership of the copyright, but there is a question there of which rights are you comfortable licensing out? Is your licensing policy only going to authorize copies, or is it going to be a full-scale copyright license that includes the rights to public performance and public display? You want to be careful to minimize who you give the derivative works right to. Most of the time, if you're licensing your work out to somebody, they shouldn't get the right to derivative works unless that's what they'll be doing. If they're going to create a sculpture based on your painting, or a painting based on your photograph, or a film based on your book, then of course you need to give them the derivative works right. But in other situations where that's not what the licensee is going to be doing, you don't want to accidentally give them that right, because it's going to give them more freedom than maybe you think. So we can talk about that more in detail. And then the last other couple things to think about are what formats will you deliver the work to? What formats do they need? Maybe you want to sort of have a standard way of going about that, a standard turnaround time. That way you kind of get to control your own schedule a little bit more and not really create an opportunity for the client to think that they are in charge of you. And then in the commission setting, the copyright ownership is really important, because like I mentioned earlier, people who hire artists for commission projects tend to think that they just automatically own the copyright just because they're paying you, but that's not how the copyright law works. And so having a standard policy of how copyright ownership will be handled in commission settings is probably one of the most important things I can impart upon you. I've had a number of clients who have had legitimate copyright infringement disputes because there was no contract that was used that established that ownership. And so even though the artists were in the right because the default provisions of the law say that they are the owner, the other side was convinced that they were right and would not budge because they thought that they owned the work. But a contract that has explicit ownership terms will help avoid that situation entirely. Along those lines, one last thing I'll mention is for commission works, you could have basically two different pricing options, right? People can come to you and say, I want to hire you to create this work. And you can say, okay, well, I can do this and give you the physical work, provide the painting or the sculpture or whatever it might be. And I'll give you a license to display that work on your front lawn or in your house or something like that, or in a gallery. But I, as the artist, am going to retain ownership in the copyright. And there's a certain price for that. Now, if the commissioner wants to actually own the copyright, well, then that gives you a very easy avenue to say, price option number 2, where you own the copyright and I give up that ownership, is going to cost you more. And that can be something that you sort of think through in advance and have sort of a standard policy. That way, again, when people contact you, you're already ready to go and you know what you want to say to them. And that can really help maximize your revenues, really help sort of strengthen your perception among, other possibly more sort of resourced companies and other things like that. So, all right. So I think we're in pretty much our last slide here coming up, just to talk briefly about collective management organizations. To be honest, this is an area I actually only just recently started learning about. I didn't even realize that these organizations existed for visual artists, but there are two that I know for sure in the United States. They're both free to join. And basically what they do is they collect royalties that are generated whenever works of art are reproduced. And to get into the specifics would maybe take a little more time than we have, but the short version is that in most countries outside of the United States, there is a special type of right recognized by other countries' copyright law known as the resale right or the reprographic right, which just means the right to make copies in sort of ordinary settings, right? So like photocopies in a book or something along those lines. And in those countries that recognize the resale right, they have organizations that actually collect fees and taxes and other payments whenever works of art are reproduced. And not just visual art, but actually books and some other types of works as well. And those organizations collect those. And whenever it's a US artist whose work is generating those fees, they actually send those fees to these two organizations, the American Society for Collective Rights Licensing and the Artists' Rights Society. And these organizations in turn take those royalties and pay them out. And like I said, they're both free to join. So this is something where if your work is already out there published in the world and it's being used in some way, it's probably a good idea to at least sign up for these and see if they have something there for you. And even if they don't right now, but you're looking to grow your business and get your work out to the world more, these organizations, as long as you're a member, will continue to pay out for them. So I've provided the links to their websites here. Definitely recommend you at least go check them out, read through the information on their websites. Seems like from what I saw, it seems like a pretty simple process to sign up. And it's money on the table that's kind of sitting there waiting for you. So that pretty much covers everything. And I have one last slide here with some resources and more information. The Copyright Office circulars are basically short PDFs. They're generally from 1 to 5 pages long, and they're on specific topics. And they give you kind of a plain English explanation of how certain aspects of copyright law work. And they provide a great guide for how to register certain kinds of work. So I've listed a couple of the circulars here that are probably most relevant to the attendees today. You can go to copyright.gov/circs to find these. Though interestingly, Circular 9 does not show up when you go to this website, so I would encourage you to navigate directly to this link, copyright.gov/circ/circ09.pdf, to learn about work for hire issues. I've also included 2 extra slides at the end of this presentation covering releases and work for hires that I'll navigate to so that it gets picked up by the recording, but I'm not really going to talk about them. And if anyone has any questions about those, definitely feel free to email me. There's also a lot of other great resources out there on contracts, on the concept of fair use, which I know comes up a lot for visual artists. The Copyright Office about a year ago actually rolled out this really great database called the Fair Use Index, where you can actually read through federal cases that addressed fair use issues and see how they ruled, see how they played out. And there's a lot of different filters and things you can use, so you can actually really narrow it down to just cases dealing with paintings or photography. You can do cases that involved the internet, cases that didn't. So there's a lot of stuff you can play around with. So and the other thing is that they provide a summary of the case. So it's not like you're jumping right into reading the judge's opinion, which can sometimes be hard to digest, but they actually have already digested it for you. So if you are in a situation where you think fair use might apply, this can be a good first place to go to see, you know, how courts are handling similar situations to the one that you're in. And then I've provided other links here as well. So that's pretty much it, like I said, but I do have these two other slides I'm going to navigate to. But before we get to that, I've just got my contact info up here. In case anyone wants to get in touch, you can find me on Instagram and Facebook. You can also navigate to my website, hasslawfirm.com. And a huge thanks to CBCA for helping organize this. This came together in just a matter of a few weeks, and really appreciate the folks at CBCA, Meredith and Rachel especially, for providing this platform to share this information with you guys. So like we said, this will be recorded and these slides will be made available in probably a day or so, but I am going to just click to these next two slides so that they're in the recording.
Cool. Thanks, Max. I'm going to chime back in. That was fabulous. I know I actually learned a few things as well that are really helpful. That was terrific. And we hope you all learned a lot as well. I did want to mention CBCA is doing tons of webinars right now. And because you talked, Max, about making sure your online presence was as good as it can be and your social media, we actually have two webinars coming up on just those topics. So April 14th in the evening is on Instagram for your creative business. And then Tuesday, May 12th, also in the evening, is on your overall online presence. So talking about your website and SEO. So check out our website for those. Registration is live. Thank you all for being great participants, sharing questions. Thank you to Max for this terrific presentation and all these great resources. CBCA is available if you have other questions, if there are other topics you'd like for us to present on, please don't hesitate to reach out. And we wish you all the very best. Thank you.
Thanks, everybody.